Good morning, everyone, and welcome to the launching event for CENTROW, the Centre for Transformative Regulation of Work. My name is Roger Ronnie, and I am one of the core staff in CENTROW at the moment. We're in the process of consolidating and setting up CENTROW, and we're extremely excited about today's event. We're also extremely excited about the group of people that we managed to get together to come and talk to us a bit more about labour law and inequality, where we've come from and where we're going to. So I think it's absolutely amazing that we have three really great speakers with us, moderated by Professor Paul Benjamin, who is the acting head of CENTROW. And we will have with us Professor Eddie Webster, Professor Sandra Fredman, and Dr. Pamhidzai Bamu, who will sharing their insights about labour law, and more especially how changes in the workplace, particularly the advent of the so-called fourth industrial revolution and the forms in which workplace delivery has changed, how these things have impacted on labour regulation. So we think it will be an extremely insightful and useful interaction with these people. All the participants are free to lodge any questions in the Q&A section, and keep whatever questions you might have for any of the panelists. Just indicate, if you do lodge a question, who you would like to direct the question to, or if you have any comment that you might want to make on the issue, that will be fine. Just to introduce the other people that we have with us this morning, the first person to extend a welcome on behalf of the University of the Western Cape would be Ms. Yasmin Forbes, who is the chair of the Council, Western Cape Council. And it's quite significant that her area of expertise is one which falls flat bang almost within the area of work and occupation of CENTROW. So in that sense, we're both fortunate to have the chair speaking, but also just the significance of the chair. We also would want to welcome the Dean of the Law Faculty, who has played an extremely instrumental role in getting CENTROW off the ground, and has continued to display an enormous support for the initiative that started off with a niche area relating to labour law in the fourth industrial revolution, and has evolved to CENTROW and the formal launch of CENTROW today. So in that sense, we're also grateful, and we look forward to hearing a word of welcome from Jacques de Ville as well. Then Professor Darcy du Toit, a labour law practitioner of long standing, who was instrumental in the establishment of the Social Law Project, one of the units that comprise CENTROW, and was also extremely instrumental in driving the formation of the niche area and subsequently the establishment of CENTROW. So in that sense, Darcy will share a few words with us on what CENTROW's focus areas of focus is, and what the key founding projects and the research initiatives that CENTROW will be taking on in the next few years. Then the substance, the real important part of the seminar is the panel discussion, which would be moderated by Professor Paul Benjamin. Paul is also a labor lawyer of long standing, an academic of long standing, and in fact continues to play an extremely important role in advising government, etc., on any changes that might be considered to the labor regulation as we go. So in that sense, we're extremely glad to have Paul moderating. And as I mentioned, the three panelists are also practitioners of long-standing, academics of long-standing, who I think will add an enormous value to today's session. With that being said, I'd like to call on the chair of the UWC Council, Yasmin Forbes, to say a few words of welcome to all the participants.
Thank you very much. Can you hear me okay there, Roger? Can you hear me? Thank
Perfectly.
you. Good morning. A crisis more severe than the Great Depression of the 30s, the 1930s. That's where we find ourselves. That's where we are today. And that is the impact of COVID-19, the pandemic, on the world of work today. This noted in the ILO Monitor, the 7th edition. Today, with the launch of the Centre for Transformative Regulation of Work, where the focus is labor regulation, as noted, dedicated to improving our understanding on how law should respond to inequality and the ongoing change of the world of work driven by technology and the structural transformation. No doubt, challenging times ahead. This, coupled with what is projected as the legal trends. The legal trends is noted as, firstly, cybersecurity, an increase of about over 400% of cyber attacks, ransomware attacks, the impact of that on business and workers, commercial bankruptcy on the increase, companies and workers, the stimuli measures that were put in place during this pandemic will soon expire, the impact of that on businesses and workers. The need for diversity and inclusion to improve that and to be inclusive of cultures. The reclassification of gig workers, and these are the independent workers, the online platform workers, contract and on-call workers, the need for guides on how to, the needs for processes to support that, and procedures for these workers. There's a huge shift in commercial estate, the impact of that on landlords and tenants and real estate in general. However, one of my concerns as we deal with the digital transformation in the workplace is data revolution. Big and always noted and quoted in the Fourth Industrial Revolution. The reason being, there's a large and a lot of focus on the projection of analytics, and this being extracted from data that is going to provide far better insight for decision making. What concerns me is the data collection, past and future. Is it equitable? Is it inclusive? The question I have is, what biases were at play when designing those questionnaires and interviewing? That is a concern. As the Chair of Council of the University of the Western Cape, I'm excited to join you here this morning, seeing a strategic intent visualized in our institutional operating plan now being realized. I look forward to the discussion here this morning. Welcome, everybody. Thank you.
Thank you, Yasmin, for those very, very insightful words of welcome. I'd now like to call on Professor Jacques de Ville, the Dean of the Law Faculty, to say a few words of welcome as well.
Thanks very much for that, Roger, and welcome also from my side, ladies and gentlemen, to the launch of CENTROW and also to this webinar. So in a few words, I'm going to say, I'd just like to share with you some of the history of CENTROW. Hopefully it will not overlap too much with what Professor du Toit will be saying. So in 2018, Labour law in the Fourth Industrial Revolution was recognized as one of the niche areas or strategic research areas in the UWC law faculty. Now, Labour law has for decades been a field of strength in the faculty, with Professor, now Judge John Murphy, and later Professor, now Emeritus Darcy du Toit, as leading figures in the 1980s and 1990s. Under their leadership, and in partnership with the law faculties at the Universities of Cape Town and Stellenbosch, one of the first coursework master's programs in Labour law was established in 1993. Exchange programs were also established with the Universities of Leiden, Utrecht, and Missouri in the field of Labour law, with several exchange visits taking place. Darcy du Toit and John Murphy were among the authors of the first comprehensive textbook on the new Labour law dispensation, with the former serving as editor and managing author. In 1993, the Social Law Project was established under the joint coordination of Darcy du Toit and John Murphy as a means of promoting the faculty's engagement with the important social developments in the labour field at the time, as well as promoting research. It also conducted sought-after training courses and workshops on the far-reaching changes that were taking place. Jumping ahead, over the past decade or so, Labour law at UWC has had a relatively low profile, although the faculty had its own very strong and popular coursework master's program in Labour law, as well as a postgraduate diploma in Labour law, which was started in 2014. It hosted promising, established and emerging scholars in Labour law and social security law in the Mercantile and Labour law department, and it also engaged in groundbreaking projects through the social law project, such as in relation to worker participation, domestic work, and the future of work. The idea with the establishment of the niche area was thus to join forces between the social law project and the department under the leadership of Darcy du Toit and Paul Benjamin, who was appointed as extraordinary professor at UWC in 2019. This has borne fruit, and in November 2020, the UWC Council approved the establishment of the Centre for Transformative Regulation of Work, with Paul Benjamin as interim director. According to its founding documents, CENTROW's purpose is to develop a centre of excellence in labour regulation dedicated to, and I quote, improving our understanding of how the law should respond to inequality and ongoing change in the world of work, driven by technological and structural transformation. It will do so from a South African perspective, based on social justice as embodied in the Bill of Rights and the norms of decent work developed by the International Labour Organization, end of quote. We hope and trust that CENTROW will be at the forefront of critical thinking and research about conditions and nature of work in the digital economy for many years to come. Thank you for joining us for this launch, and also for joining us for this webinar. Back to you, Roger.
Thank you, Professor DeVille, for that little background on the origins and where CENTROW would like to see itself in the not too distant future. We now hand over to Professor Darcy du Toit to share some thoughts about CENTROW and where, in fact, its focus will be in the next short term. Darcy?
Thank you, Roger, and thanks also to the Chair of Council and Dean of Law for those welcoming words. I want to take you into a presentation which I've prepared, so I hope I can share the screen successfully. Can you see my screen?
It's
well,
not sharing. It's not sharing it, Darcy.
Not sharing it?
No.
And now I'm sharing it?
Now it's
okay.
sharing.
Very good. Thank you. Sorry, I've missed a minute there, so I must move on quickly then. And I must thank you to the Dean as well, as they say in Dutch, for mowing the grass in front of my feet, having covered the ground very adequately of where the centre has come from. And I don't really think that I need to add anything further to what he has said on that score, except perhaps just to explain more the thinking behind the naming, the rather complicated name that our centre has, Centre for Transformative Transformation of Work. We use the concept of work rather than labour because labour law is the normal term referring to employment in particular. Work nowadays in an economic sense takes so many different forms that it is really inadequate to concentrate simply on labour law as we have known it. And so we think the term work is broad enough to cover all the different forms of work which are not employment and not subject to legal coverage. We also use the term regulation as something more encompassing than law. It includes really any set of rules by which the performance of work is governed in the workplace, which might actually be unlawful in many cases, but nevertheless, it is the reality. We want to focus on the real world and engage with the real world. And we use the term transformative, not just because the project that we have in mind will involve the transformation of law as we know it, and labour law in particular, but also because we see it as part of the transformative project that was launched in South Africa with the new constitution in 1994 to overcome the inequalities of the past and to strive for a future in which every person can enjoy human dignity. Now, that is a huge transformation, but we think that the regulation of work, where people earn their living from, is a very, very crucial part of that. But where we really come from, of course, is not simply the organizational background, it is the vision, it is what we strive for. And our vision can be summed up in the term social justice, which is, I would paraphrase it as that which is captured in the Bill of Rights of the South African Constitution and reflected in numerous other instruments, the Universal Declaration of Human Rights, the International Labour Organization's Decent Work Agenda, and all of that, I think, involves the achievement of equality, or perhaps better said, overcoming and mitigating the deeply embedded inequalities in our society so that every woman, man, and child can fully enjoy the rights that every human being should be entitled to. And the workers are also citizens, and the rights at work and rights outside the world of work are inextricably intertwined. The second important point, labour law and worker empowerment, which form part of the initial vision of the Social Law Project back in 1993. To quote one of the founders of labour law, Otto Kahn-Freund, who said that law needs trade unions more than trade unions need the law. That captures the reality that if individual workers engage with employers, who often are corporate bodies, the relationship is entirely one-sided. The regulation of work becomes what the employer decides to have, because the worker simply has no bargaining power, no means of resistance. It only becomes a two-sided relationship once workers are able to combine, to organize, and to collectively exercise some kind of counterweight to the employer's enormous power, which is even more enormous in today's world of global corporations. I'm sorry, I keep on touching my keyboard. I'll try not to do it anymore. And so worker organization is not simply organization, it also is knowledge and understanding of how to organize, what you organize for, learning the lessons of the past, where we come from, where we are going. And that is the kind of empowerment which we think must form part of organization and certainly that is part of the vision of Social Law Project and CENTROW. And the third leg is legal renewal. That is something, a theme that's been very dominant in labour law for the last 30 years at least. The realization that law is lagging behind the changing technology, changing forms of work, and law is still premised very much in the world of smokestack factories and large offices and mines and dock workers, people working in large numbers who need to act together and whose relations with employers are collectively regulated. That is far from the reality of today's world of work. As we know, the digital economy is dispersed worldwide, and for decades now, labour law scholars and trade unionists have realized the law needs to catch up, and yet decades later, it still has only done so very partially. So that too is part of the reality that we need to understand. Why is that the problem? Where are we going? We are certainly not special or unique. We are part of a global movement. I've referred already to the lessons that labourers have drawn for decades, and that is an ongoing development which we see ourselves being part of. We therefore don't want to reinvent any wheels, and we believe that many hands make light work. We therefore try to work with our colleagues elsewhere who share the same views and who have much more to contribute than we on our own can. In particular, we are affiliated to the Labour Law Research Network, which I would describe as an organization, informal organization that includes most of those engaged in research in the field of labour market regulation. So we want to continue to be part of that. More specifically, we have strategic partnerships with what I can describe as activist or action research centres elsewhere in South Africa and abroad, research institutes or units that engage with the stakeholders which seek to make an impact in the real world, as opposed to, in addition to, I should say, the quality academic output which they also produce. We also find it very important to interact with the organizations of the workers who are experiencing these changes at first hand. Trade unions, those trade unions which play an active part in this field, which are regrettably not enough, but will hopefully become more in future if we all do our work properly. But also organizations of, I would call the marginalized workers, the platform workers, domestic organizations, those who've been excluded from the mainstream of labour organisation all along. They are the ones who've been excluded from labour law as well, to whom we are arguing and others are arguing the law needs to be inclusive of them. But for that to happen, we need to connect with them in order to make that happen together with them. Do we have a special contribution to make? Because we think all our partner organizations in their own ways make unique contributions. And what we think could be seen as our special characteristics are, firstly, our multidisciplinary approach to research. That is to say, the realization that we can't limit ourselves to simply law for legal research, because law is really, although many lawyers might disagree, is a social science. And you need to understand law in context. You need to understand what is impacting on law, what changes are changing the demands made on law, technological changes. I'm speaking of labour law in particular now, technological changes, structural changes, organizational changes in the world of work. One needs to understand that to know what you are dealing with and what you will have to deal with in the future. The world is changing. So therefore, we try to interact with those involved in fields of science and technology, economics, sociology, political science, and various other disciplines which are important, if not essential, to understanding what law has to contend with. We also, as I say, have an approach based on networking. On the screen, you can see a few faces of research associates who you'll also find on our website, a brilliant range of experts, both academic researchers and practitioners in various fields who have, we think, very, very crucial expertise and experience to contribute, which we ourselves don't have. So to make our multidisciplinary approach come to life, we need to draw on the experts in those disciplines. Then I think what is also critical and in the research that we are involved in is a participatory or an inclusive approach. Inclusive not only of academics and experts in the field, but also with the workers and relevant stakeholders themselves, the workers who are faced with the problems, who can help us to understand what the problems are, what the potential solutions can be, the workers and other stakeholders as well, policy makers, those who give work to workers, for example, in the world of the platform economy, the platform owners as well as the platform workers. One needs to engage with the stakeholders to get that three-dimensional understanding of what is going on, to understand the problems as well as the possible solutions that could work. Also known as not breaking out of the ivory tower. And then the fourth important asset, which I believe CENTROW has, is, I call it for short, the UWC ethos, that commitment to democratic change that we saw so sharply highlighted in the 1980s. On the picture on the screen, you see a demonstration on campus. In those days, it was illegal. State of emergency was in progress. The police was often there to break it up. John Murphy, whom Jacques referred to, can tell you many an anecdote of those days. And one possibly misleading aspect of this picture is that you don't really see many women there unless you look closely. But that is misleading because we have been and remain in the forefront of UWC's democratic mission. What that translates into today, for CENTROW, it means firstly, we are building on an existing tradition, a strongly internationally recognized tradition of commitment to democratic change and empowerment of the disempowered. What it also means today is an extremely supportive environment for the kind of research and interventions that CENTROW is committed to. Jacques has alluded to that, but more than that, Jacques has illustrated it, and I think Yasmin Forbes has illustrated it. That is the climate, the context in which CENTROW is privileged to operate. Now, I'll conclude by quickly taking you through some of the projects that are currently in progress. Firstly, what might be seen as a microcosm of CENTROW, namely the Digital Platform Cooperative Project. This, in short, envisages as an outcome a sustainable, cooperative of empowered domestic and care workers who use a digital platform to not just to market their services, but to organize and empower themselves. In other words, a worker-owned platform consisting of formerly of the most disempowered workers whom we can see becoming transformed into highly empowered workers, setting an example for others. This will be seen by many as hopelessly idealistic, if not impossible. That, of course, is where research comes in, because the purpose of our research is to find ways of making the impossible happen and to show it is not impossible after all. And here too, we have many best practice examples to learn from in the United States and elsewhere. And we are optimistic that wherever we go with this over the next few years, it will have a lasting impact and be a stepping stone towards.
Professor Du Toit.
5 minutes left.
No, you're way over your 5 minutes already. You've not been keeping an eye on the chat group. So can you please wrap up? Because
I beg your pardon, yes, my chat box disappeared. Okay, I will simply then say, you can see there 3 other projects that we are engaged in. Hopefully, Professor Fredman will be able to say more about the Fair Work project, Labour Law Online, and an online advice platform for workers with legal problems seeking advice. We are working as closely as possible with the Department of Employment and Labour. And to conclude then, just to ask everybody, all participants, the purpose of today's webinar is really, as part of CENTROW's launch, to gain more ideas of where we should be going, to get guidance from you, to get ideas and suggestions from you, what we should be doing and could be doing, in particular, what we could be doing together with you. I will leave it at that. Apologies, Roger, and others.
Thank you, Darcy, for that very interesting input into what CENTROW is busy with and where CENTROW wants to go in the not too distant future. So I think what you've provided for us, and for any of the participants who might be wondering, Darcy's presentation will be shared with all of you post the seminar. So in terms of notes, etc., you'll be able to go back and reference where CENTROW is going to. We now reach the reason why we have actually come together today, and that is to draw on the expertise, the experience, the knowledge of 3 people who have spent an enormous amount of time investigating the world of work, investigating labor regulation, and the extent to which that. For that, we hand over to Professor Paul Benjamin, who will be moderating this session on behalf. Thank you very much.
Good morning, everybody, and thanks to Roger and the others for such useful introductions, giving an overview, certainly something I learned from, of the important contribution UWC has made over many years in these key areas. As Roger indicated, we have 3 speakers, Professor Sandra Fredman, Emeritus Professor Edward or Eddie Webster, and Dr. Pamhidzai Bamu. Each speaker has 20 minutes. Sandra Fredman, as Roger indicated, and is not only a distinguished lawyer working in areas such as labor law, human rights and equality, but in this area has done important work in a major joint project that UWC has been involved in, Fair Work, which is produced, unprecedented levels of knowledge on the platform economy. So over to you, Sandra. Thanks very much for being with us.
Hello to everybody and good morning. I'm very glad to be here with you. I too am going to attempt to share my screen. So give me 1 second. Right, is that there? Can everybody see? So yes, just to say that with the shared screen, both my clock on my computer and the chat box disappear. So Paul, if you could just indicate with waving to me or coming on screen when I've got 5 minutes to go, that'll be really helpful. Well, so thank you so much. And I'm really thrilled to be part of the launch of CENTROW at this extraordinarily important time in the world of work. Certainly the need for a centre which concentrates on sustainable work in this new environment has been highlighted by the COVID crisis, which hasn't just caused new inequalities, it's revealed and deepened existing inequalities. And more than anything, it's shown up one of the great fissures in labour law, that is between the ins and the outs. So those workers who have secure jobs are able to get sick pay when they need to shelter at home. Their homes can be offices. They have the kind of work that can be done from home. They have the access to internet, to space, to silence, to water. They can school their children. And so they can keep earning their salaries and wages and keep themselves safe from risk at the same time. Whereas on the other side, precarious and poorly paid workers without sick pay are not doing the kind of work that can be done from home, and their homes are also unsuitable for work, for homeschooling. They have little access or none to the internet, to crucial water to keep them safe, even to security from violence within the home. And we know that domestic violence has spiked during the COVID crisis. So the outs then are either exposed to the risk of infection in going to work, or so many have lost their jobs. So my brief from Darcy was to look back, which is a huge brief in just the remaining 15 minutes that I have. So what I wanted to do in this short time is to look at two main themes. The one is that actually there are more continuities than discontinuities when we look back at labour law, and actually that labour law has always worked on a foundation of ins and outs. And secondly, what I'd like to centre in this discussion too is the role of unpaid work, and look at that from a feminist and intersectional perspective. So as far as unpaid work is concerned, very briefly, at the time of the first industrial revolution, there was a division of work into work in the home and work out of the home in factories, mines, offices, etc. And work in the home at that time was no longer considered productive work. In fact, in the UK, the calculation of GDP no longer considered work in the home as productive work from in the early 20th century, and that's been recorded. So women's work becomes unpaid and invisible. Now, this isn't just a kind of quirk or an aspect, an element of labour law. It has ripple effects into many different areas. So because work like cleaning, catering, childcare, laundry can be done unpaid at home, it's also undervalued in the market. So it's not a surprise that these kinds of works, which are highly gendered and racialized, are paid so much less, and gender pay gaps remain, job segregation remains. And at the same time, the continued prime responsibility for domestic work and childcare work, elderly care, constrains the time that women have to engage in the labour market, and that means that their choices are very limited, often pushing them into part-time work, temporary work, agency work, and other kinds of precarious work, and into the informal sector. Now, this isn't just about unpaid work in the home. Working class women in all countries, in the UK, in South Africa, and everywhere, have always had to undertake paid work, but this has been in the form of precarious and underpaid work, all of which is invisible to labour law. The most that labour law historically has seen this is through the notion of a family wage, which is in itself disempowering because it sees male workers as responsible for earning enough to cover the family itself. Now, in South Africa, this gendered labour market, the class and gender side is overlaid with race, the heritage of apartheid through job reservation, influx control, racial segmentation means that both Black men and Black women are in highly exploitative work, although also in a very gender segregated way. So what is the role then of labour law, and how does it reflect, entrench, or mitigate these fissures on the one, both the insider-outsider boundary, as well as the way in which paid work and unpaid work are separated so that unpaid work becomes invisible with the ripple effects that I've seen? Well, first of all, labour law doesn't just arrive on the statute books. It only comes with struggle, and collective organisation has been crucial to getting labour law into legislation, into parliament, into the books in all countries. So you need collective organisation, you need struggle to get legal rights in the first place. But on the other hand, you could also see labour law as a kind of appeasement, where capitalist employers prefer the more orderly dispute resolution that you get through labour rights than you might get through industrial action. And in the UK, for example, it's clearly documented that in the 1970s, employers preferred to have unfair dismissal protection in labour law than to have a continuation of wildcat strikes around dismissals. On the other hand, and this is the other fissure around unpaid work and caring work, if you were unorganized workers, women, precarious workers, racialized workers, you were not part of the collective organization that could gain the collective rights. And what happened to rights for these parts of the workforce? At most, they were protected to when the workers who were protected by labour rights were worried about undercutting. So if women workers could offer work at lower pay, then male workers might agree to equal pay laws for men and women. And the other way in which this could be manifested is through protective legislation, such as the early ILO conventions, which are reflected in many countries, protecting so-called excluding women from night work and underground work in mines. In India, these exclusions remained until very recent decades, where women were not allowed to serve alcohol in hospitality. And the trouble with that is it works on exclusion rather than on leveling up. So if you're worried about conditions of work underground in mines, you should rather improve that for everyone than exclude women. The other way in was the insider-outsider fissure was cemented was to ring fence labour rights to those under the control of the employer. And of course, this helps to maintain order by segmenting workers as insiders or outsiders. So although the insider workers gain a lot and manage to achieve important labour rights, the crucial challenge going forward is how to also shape labour laws so that it doesn't continue this segmentation. In South Africa, this is being heightened in the racialized form in which workers were excluded all the way back to the Industrial Conciliation Act in 1923, which excluded Black workers from the definition of worker. So has South African labour law, which is a model labour law, which came out of the transition to democracy, this is a model labour law, and to what extent has this addressed these issues? The issue of insiders and outsiders, and the issue of unpaid work. Well, there are many others here who could talk about this in a lot more detail and with great expertise. But so I just want to look firstly at domestic work and then more generally at the insider-outsider boundary. So on the plus side, actually South Africa is way ahead of so many other countries in having a sectoral determination for domestic workers. And the Centre for Social Law, Feroz, Darcy and others have been so important in forwarding rights for domestic workers, most recently in the form of including domestic workers in COIDA, in the Mashlangu case, and of course, forefront of the ILO convention. But on the other hand, if you look at the terms and conditions of domestic workers, which I think reflects the undervaluation of domestic work generally, the gendered and racialized aspect of it, minimum wages in the sectoral determination themselves are very abysmally low. The national minimum wage legislation has a separate rate for domestic workers, which is lower than others. This discriminates against domestic workers, but also I think indirectly discriminates against women who form the vast majority of domestic workers, particularly Black women. Domestic workers are still difficult to organize because organizational rights, even if they are available to domestic workers, are based on a standard employment model. Compliance and enforcement are difficult. For migrant domestic workers who are tied to their employers, their situation is even more precarious. And platform domestic workers, which I've been working on with Darcy in the Fair Work Project, are in a particularly precarious situation. Elsewhere within the labour law structure in South Africa, there are still the very many outsiders who, although they are called self-employed, actually do not have the kind of agency and independence you would, that is the idea of keeping labour rights to employed workers is premised on. So whether they are platform workers, which, as Paul said, we've been working on a lot, many of them are called self-employed, whereas they are actually really subject to the control of the platforms. But even if they are self-employed, they still have a right to decent work. Others who are left out are migrant workers, workers in small enterprises, workers in the informal sector, such as street vendors, which Pamhi will talk about, and of course, the interaction between paid and unpaid work, which should be reflected in a comprehensive social protection floor. So just as a final set of points, bridging the gap between my brief, which is looking backwards, and perhaps how we might look forward by thinking out of the box. We could look to other sources of law. For example, in the Fair Work Project, we've tried to get round restrictive notions of employee by looking also to consumer protection law for informal workers, such as street vendors, city bylaws.
Hi, Sandra, just to say it's 5 minutes left. Thanks.
Okay, I'll be done in 5 easily. Thank you, Paul. So Bamu has worked a lot on street vendors, and I'm sure she'll say more about this aspect. A second way in which labour law should be adapted for different kinds of work is when we look at minimum wages. Self-employed workers, such as workers on the platform economy, often have to bear many of the costs of their employment, such as fuel, insurance, hire of cars. These should be taken into account in applying minimum wages outside of the existing labour law framework. Waiting time in employment such as Uber, where its business model is based on having a surplus of workers, waiting time should also be calculated for minimum wages. So far as health and safety at work is concerned, the workplace needs to be much more widely defined. We have an example in the ILO Violence at Work Convention. For street vendors, there needs to be safety on the street, proper sanitation, proper childcare, protection against violence. The social protection net needs to be much wider so that it's not just a reservation wage, but it also protects for all kinds of parental rights, healthcare and sick pay, which have become even more crucial during COVID. Equal pay for work of equal value needs to be seen in a much more comprehensive way, potentially putting proactive duties on employers. And as Darcy mentioned, collective organisation should be seen in lots of different forms, cooperatives, WhatsApp groups, and other kinds of collective employment organisation, which are not focused on specifically a gathering of workers in a workplace. So that brings me to the end. I've tried to look back with, as I said, a feminist intersectional perspective, galloped through a lot of different themes, but basically the continuities of the ins and the outs, and the centrality of the idea of the invisibility of unpaid work, which ripples throughout the labour law structure. Thank you very much, and thank you for having me. Thank you for listening.
Thanks very much, Sandra. And our next speaker is Professor Edward Webster, who's currently the Distinguished Research Professor in the Southern Centre for Inequality Studies. Eddie has been involved in the labour relations issues going back to the early 70s. We can't cover all of its activities, but currently, and particularly appropriate for our project, is that he's working on a book on equality and a work in inequality in the digital age, a global South perspective on the future of labour. So it's a great honour to have Eddie as part of our program. So over to you, Eddie.
Thank you for this opportunity to participate in this initiative by the University of the Western Cape. It's a very timely intervention, and it's a great privilege to be participating in it. My current research is on new technology and the changing world of work, but also the changing attitudes towards work. And I would like to share with you this morning the research we're doing on the platform economy, in particular on the particularly on the food couriers in Johannesburg. And I have with me my co-researcher, Fikile Masakane, who I'm going to ask her to join in. So let me begin. Incidentally, can you see me?
Yes. Yes, we can see you, Eddie.
Fine. Thank you. On the 18th of December last year, in response to a fare decrease, 1,000 food couriers collectively logged off of the platform, forcing Uber Eats to halt operations across Johannesburg. Scores of couriers in Tshwane, in Durban, and Port Elizabeth also collectively logged off the platform. The couriers released a memorandum of 12 demands. Increased fares was the primary demand of the couriers. These demands had been formulated and the strikes organized over WhatsApp groups. The organizers of the strike managed to overcome the platform's attempt to isolate them by communicating through multiple WhatsApp groups. This was the first citywide strike of food couriers in South Africa, and is unlikely to be the last. Strikes have played a crucial role in shaping South Africa's economic and political history. Indeed, many years ago, the mass strikes in January and February 1973 in Durban proved to be a turning point. It led to the reform of the industrial relations system, eventually allowing for the formal recognition of trade unions for Black workers and their right to join the established collective bargaining system. But despite the intention of our new Labour regime and the ILO to build an inclusive industrial relations system, many workers remain excluded from the regulatory framework introduced in the 90s. The process of increasing informalization of the labour market has created a gap between trade unions and a growing number of workers who have no forms of collective representation at their places of work. This has been labelled the representation gap. In part, this gap is the result of a trend towards the decentralization of production and the accompanying outsourcing of workers to a third party. In other cases, it has risen from the trend towards casualization, part-time, temporary employment relationships. It's sometimes the result of retrenchment of workers in the face of hyper-international competition and the drive to cut labor costs, something, of course, that's been accelerated during COVID-19. The result of these processes is a growing number of workers, increasingly cross-border migrants, engaging in survival-type activities as street traders, waste pickers, men digging in abandoned mines, what come to be called the Zama Zama. More recently, that included food couriers in what has become known as the platform economy. Side by side then with the standard employment relations are growing numbers of women and men out of reach of the regulatory system. As Adele Blackett wrote in a recent paper, reflecting on the history of capital and labor, and I quote, "Economic liberalism and unfree labor emerged not as polar opposites. Rather, economic liberalism has historically and systematically depended on multiple overlapping forms of free and forced labor," unquote. In fact, the rigid binary between free and forced labor does not fit our colonial past and history of work in South Africa. The traditional distinction between direct coercion, or physical coercion on the one hand, and the voluntary recruitment of workers on the other, something that used to shape industrial relations and the ILO thinking, does not capture the continuity from slavery, indentured labor, the migrant labor system, through to the use of casual labor in contemporary South Africa. In recent years, the ILO has begun to break from a past when industrial relations theory and practice seemed more comfortable with traditional unions and clear-cut employer-employee relationships. I'm thinking in particular of recommendation 204, transition from informal to the formal economy. That recommendation opens the door for a more decisive recognition of the rights of informal and migrant workers. Blackett goes on to argue in the paper that I've mentioned for what she calls an, and I quote, an emancipatory approach to labor law, which calls out less for focusing on the exceptionality of illegality and more on the structural challenge that is attentive both to exploitation and to historical forms of dispossession. In other words, she goes on to argue the anxiety over contemporary slavery in Europe specifically and the global north more generally is inseparable from a globalization that fails to face the conditions under which people continue to move across territory and how asymmetrical migration law and global governance makes people illegal, unquote. Indeed, to illustrate Blackett's argument, I want to focus on our current research on platform work in Johannesburg. Now, we're engaged in what one called, well, I suppose one could call ethnographic research, which means we try to capture the meaning and the precise nature of this work. But it's useful just in introducing the research to draw that distinction between within digital labor platforms. I mean, the digital platform allows individuals or business clients to arrange a ride or order food, etc. By connecting businesses and clients to workers through the app, through the digital application, they are transforming labor processes with major implications for the future of work. And you can classify the digital labor platform into two broad categories. You have online web-based work. And secondly, you have location-based platforms. The online web-based platforms, tasks or work assignments are performed online or remotely by workers. The tasks on location-based platforms are carried out in person, in specified physical location by workers. I'm talking about taxi drivers, delivery, home services such as a plumber or electrician, domestic work, which was mentioned by Professor Fredman in the previous input, such as Sweep South or Made for You, and of course care work, care provision. Now, it's interesting in trying to get a handle on this category of work that it's only, according to the way in which we've been able to calculate it, it's only 1% of employment in South Africa currently. There's roughly, if you take the online web-based work, it's about 100,000. And if you took the location-based demand work, it's 35,000. These are estimates. These numbers are, of course, very low. They are nowhere near the big players in retail, mining, logistics, healthcare, manufacturing. But what matters, I want to suggest, is less the actual size of the workforce, but more the way they are changing the landscape of the wider economy. They are an example of what has become known as disruptive innovation. Disruptive innovation in that they circumvent existing rules on employment, social protection, and indeed also corporate taxation. So this is a key. It's innovative, but it's disruptive. Importantly, the regulatory differentiation between genuine self-employment and the bogus variant remains unsolved in the platform economy. However, the recent decision by the UK High Supreme Court in Uber versus Aslam marks significant progress for these riders. The court held that the claimant Uber drivers should be considered as workers for purposes of UK labour legislation, as workers represent a type of hybrid between an employee and an independent contractor. But there's a second point about platform work, in addition to the relatively small numbers, and I guess that's more important, it's increasing rapidly. If I just take the Uber Eats, in 2016, when they first entered the market, there were roughly 500 active couriers. At the end of last year, there were 8,300. That's a massive percentile increase, a very rapid growth trajectory. So what I'm suggesting is that a new worker has emerged in the digital economy that is subject to a new business model based on a form of algorithmic management. It promises freedom, flexibility, self-employment, and shared business ownership. These new technology companies, and I'm talking about the range of Uber's one of those, are opening up new economic opportunities in Africa. Indeed, our next research will carry it through to Nairobi and then to Accra. However, in our research on food couriers in Johannesburg, a different picture emerges of a new form of precarious informal work, consisting largely of undocumented migrants, working long hours, lacking paid leave or social security benefits, and paid below the national minimum wage. They face constant risk, accidents, and harassment, and lack any occupational health and safety protection. By classifying workers as independent contractors, companies bypass the rights of workers that are found in more traditional employment contracts.
Eddie, it's 5 minutes left. Thanks.
Thank you. Despite this, the worker is still subject to considerable control by the platform or parent company, and their performance is central to the company's core business. Workers are essentially managed through the online platform or the app where they clock in by logging into the app and then becoming subject to algorithmic allocations of tasks to be performed at predetermined pay rates. But algorithmic management is a double-edged sword. On the one hand, it is leading to an extension of authoritarian managerial control over workers, increasing the insecurity and deepening levels of inequality. On the other hand, by technology linking workers, they have increased their workplace bargaining power, providing them with the ability to develop collective solidarity and even strike action. We identified in our research union-like hybrid collectives, offering mutual aid and opening up the possibility of the couriers withdrawing labor by collectively not logging in. This is the 21st century version of a strike, collectively not logging in. The problem for the platform workers, as the ILO notes in its report on digital labor, is that the same digital labor platforms, in some of the digital labor platforms, there is excess labor supply, which leads to greater competition among workers for task assignment and puts downward pressure on the price of the task to be performed, unquote. However, at the core of the regulatory challenge faced by platform worker is the ambiguous nature of their activities. This ambiguity emerged in this conversation between two drivers, and I'm going to pass this on to my researcher, Fikela, to speak.
Okay. So as Eddie said, that we had conducted an ethnographic research, and part of the questions that we had asked the drivers was how they managed during level 5 lockdown. And this was a conversation between Uber Eats and Mr. Delivery drivers. And the Mr. Delivery driver was explaining that during level 5 lockdown, they were given 1,000 Rand a week to make up for the time that they were not working, whereas Uber Eats was not receiving any form of assistance or any form of money from Uber Eats. So the conversation was that Uber Eats does not care for its work, doesn't take care of its workers necessarily, whereas Mr. Delivery is taking care of the workers. And the interesting part of the conversation was the fact that the Uber Eats driver saw that as being independent and more flexible as a driver, as opposed to Mr. Delivery, which seemed as though they were not drivers are.
This interesting conversation between the drivers highlights how they understood the nature of the relationship between themselves and their employer. On the one hand, some form of independence is wanted by the drivers, while at the same time they want to have benefits as employees, especially during this period of hard lockdown when they had no access to work. So let me just conclude. Some countries have started to address this regulatory gap in digital platform work, with examples of countries extending social protection in Australia, New Zealand. Statutory language on occupational health and safety has been extended to cover platform workers. Several countries have introduced innovations to extend social security to platform workers. In South Africa, we have the Code of Good Practice in the regulation of platform work in South Africa, developed by the Fair Work Project. What is clear is that the time has arrived for us to revisit the regulatory framework set up nearly 3 decades ago. But I want to end with a word of warning to my legal friends. Do not simply transfer effective labour market institutions from the global north, as we did in Chapter 5 of the Labour Relations Act, which introduced German-style works councils. Effective labour regulations require a detailed understanding of how work is performed. This is especially true of platform work, where whether you are an employee, an independent contractor, or some intermediate category, depends on a concrete understanding of how much control is exercised by the platform versus how much flexibility and autonomy is exercised by the driver or the rider. But ultimately, what we introduce must be something that the women and the men who ride the scooters want. And this will only happen once these workers become part of a process of ongoing social dialogue between the companies on one hand and the drivers on the other. Thank you very much.
Thanks very much, Eddie. And thank you for keeping to our time limits. Our final speaker is Dr. Pamhidzai Bamu, who many of us know. She was a PhD student at UCT and has been deeply involved in the work of WIEGO, which I'm sure she'll tell us about. And a particular thanks to her for having woken up very early in the morning in the USA. So over to you, Pami.
Thank you very much for the introduction, and I think it's afternoon there. Good afternoon, colleagues. Thank you for joining us. Good morning to those who are in the Northern Hemisphere like me. Thank you for joining us as part of the launch of CENTROW. So I'm going to speak in maybe pulling things together and speaking a bit about different forms of work and how we see the practical manifestations and how we can move forward. 20 minutes is not a very long time. So without further ado, can you see the screen?
Yes.
You can, okay. So, I think great minds think alike. Sandy had a slide that was similar to mine. And I think the point that she raised is very, very apt. When one looks at the labor markets, particularly in developing countries, if you look at a country like South Africa, it just seems like it never rains. And COVID has just really heightened and highlighted the deep-rooted inequalities that we see within the labor market. So I'd like to speak about the practical manifestations of inequality, and I'm taking a holistic perspective. So I know that CENTROW has quite a niche in the digital platform work. But if one looks holistically at what is happening in terms of inequality, what we see is a pattern of segmentation of workers, where there are different levels of labor and social protection. If we were to visualize it, we could look at it as, you know, some workers being at the core and others being at the periphery, or some workers being at the top of the pyramid and others being at the base. There are different ways to visualize it, but we see that there are workers who are either not protected in law or they're not protected in fact, or both. So on the one level, we have workers who are in the standard employment relationship who are becoming more and more of the exception rather than the norm. Secondly, we are seeing that they're paid employees who, for whatever reason, are outside what we would imagine as the standard workplace, where, you know, an industrialized workplace or an office kind of setup. Particularly if you look at domestic workers, you may look at workers in the informal sector, for example, people that work for street vendors. We could also look at out workers and home workers as well. And the rise of non-standard employment or precarious work, where we are talking about casual work, part-time work, fixed-term work, and I'm calling them multilateral arrangements. We have often spoken about triangular employment relationships, but more and more the complexity of these relationships increases, and you have several intermediaries, and therefore I refer to them as multilateral arrangements, where there's a labor broker, there's a subcontractor, and layers of different parties. And we also have disguised employment relationships, which include out workers, home workers, and gig economy workers, where the idea is to create the illusion, I guess, of a commercial relationship, which creates that distance between the worker and the employer, and therefore ensures that the worker cannot claim their labor rights. I think both Eddie and Sandra spoke to this. In some ways, the multilateral arrangements also bring about the disguising of the employment relationship by adding this commercial arrangement. We also have own account workers, such as street vendors, such as waste pickers, whom we work with at WIEGO. These workers are not employees, but particularly these two sectors have a relationship with the local authorities, whether acknowledged or not, because much of their work takes place in public space or on public spaces that are owned by local authorities. And so the local authorities have a significant impact on the nature of their work. And I think it's important to speak to the point that Eddie spoke to towards the end of his presentation, where he spoke about context and context being important. And this idea that we've adopted laws from the global north, developed for the global north, and the reforms in the labor law thus far have focused primarily on the idea of changing forms of work, which may not necessarily be what is most significant in a particular country. So particularly in the developing world, I do think though that South Africa is significantly different from other developing countries because it has a larger formal economy than most countries. A country like mine, Zimbabwe, you know, we'd be looking at about 10% of the labor force being in the formal economy, and that applies to many other countries. But in South Africa, the formal sector itself is larger, but we need to take into consideration the developing country aspect of it and look holistically at the labor market. And that's why we're looking at people like own account workers, street vendors, and so on. Whereas in the global north right now, the preoccupation is around, yes, there's the fourth industrial revolution and the digital economy and so on. So that's a picture of a domestic worker in South Africa, and arguably one of the most vulnerable sectors that we work with. Now, coming to the practical manifestations, I won't go into too much detail because I think both Eddie and Sandra spoke to this. But we have exclusion in law or in fact or both. And we have insiders, outsiders, core and periphery, and the hierarchy of workers. There are issues around basic working conditions which relate to pay, and pay may be wages or pay may be earnings, a worker's earnings, the ability to work, their working hours, how they're regulated, whether they're regulated, whether there's overtime in a situation where that would apply, is paid leave an option? And then importantly, there are issues around freedom of association and recognition of the workers' organizations for purposes of collective bargaining, for purposes of social dialogue. So if we look, for example, at the platform workers and their organizational forms, would they ordinarily be recognized for collective bargaining? Would they be allowed to the bargaining table? And when it comes to social dialogue, to what extent are these workers' organizations being admitted? I think South Africa is more progressive and has brought in the community sector. I think Pat Horn is here, and I have colleagues from WIEGO who have been part of some of the discussions within NEDLAC around recommendation 204 and generally around COVID-19, but I think there have been changes even under COVID-19 where there's been greater access to these platforms. Occupational health and safety protection is a huge issue and a huge challenge. Social protection, particularly around unemployment, workers' compensation and pensions, where many of the workers that we're talking about are excluded from forms of social insurance. And during the time that they're workers, may earn too much to be able to benefit from social assistance. So they form part of what we call the missing middle. And protection against termination of employment in situations where this applies, you could be talking about a domestic worker. To what extent can she assert the right to a fair reason, a fair procedure, and to be able to claim compensation for termination of work? And I think it's important to highlight the point, I think that both of the previous speakers spoke to, is the disproportionate impact on women and on previously disadvantaged, which is Black communities in South Africa, and migrant workers who largely fall within these categories of unprotected workers or precarious workers. These are pictures from a market in Durban. Workers within that context, a bovine head trader, and yes, that's also bovine head. And there is a picture of a sort of makeshift first aid table where one can access support, which is very different, I think, from what one would expect within the context of a formal workplace. So coming to COVID, I think COVID has really been a reality check on the exclusion of workers, and it's highlighted the danger of these inequalities and the fact that we cannot continue on business as usual. Particularly where, with the lockdowns, social protection is a luxury for many, particularly unemployment benefits and workers' compensation. Although South Africa, I think, it has been more progressive than most of the African countries that we've come across in terms of extending the COVID-19 benefits to different categories of workers, including self-employed workers, and allowing workers' compensation for those for regardless of one's occupation. But the occupational health and safety protections and the obligations in terms of who should provide for sanitizing, who should provide for PPE, that continues to be contained and to be limited to the workers in the formal sector and the employees, strictly speaking. Other workers have to fend for themselves and may be fortunate if, for example, within the within a market, for example, the local authority sanitizes the space within which they're working. Limited application of, or no application of, provisions related to time off and sick leave. So for those who are not the privileged standard formal employees, being away from work because of COVID-19, because they have to take care of people or take care of themselves, doesn't bring any benefits. It means no work and no pay. We've seen just in this period that there has been more of a shift around the extension of COVID relief to all categories of workers, so including self-employed workers and self-employed and workers' compensation regardless of one's occupation. And there has been a renewal of the debates on the basic income grant. I think it's coming out of a realization that the status quo cannot continue, but how this plays out is what is going to make the difference in terms of whether this leads to long-lasting change. I think with things like the basic income grant, there is progress in that regard. Here's a waste picker. So within the South African context, one of the challenges has been that with COVID and with the lockdowns, with waste pickers not being recognized, there was a risk that if they were not able to work during the lockdowns, their work would be taken over by private companies who would, they get the contracts to collect the waste, and that would lead to their loss of their livelihoods. And so this was very important for for them to strive to protect their right to work, as it were. So I think in terms of the mandate for more inclusive protection of workers, we have a constitution in South Africa that speaks about rights, including equality, dignity, fair labor practices, which are extended to everyone and extended to every worker. Internationally, there are a range of instruments that use a very broad and expansive language that speaks to everyone or all workers. We have, for example, the International Convention on Economic, Social, and Cultural Rights, the Convention on the Elimination of Discrimination.
Pamela, if you just finish in 5 minutes, thanks.
Sure. Thank you. And the Universal Declaration of Human Rights. We also have a range of international labor organization instruments and jurisprudence that relate to the extension of rights to all workers. Particularly if we look at the Committee of Experts on the Application of Conventions and Recommendations, the CEACR, which has interpreted several key conventions to be extended to informal workers. For example, the Occupational Safety and Health Convention and the Convention on Social Protection. We also have the Decent Work for Domestic Workers Convention, which South Africa has ratified. We have the Minimum Social Protection Floors Recommendation number 202. And importantly, Recommendation 204 concerning the transition of the informal to the formal economy, which speaks about workers in informal economic units and workers in informal economic relationships, and seeks to ensure that workers in the informal sector, so to speak, enjoy labor protections, and to curb the informalization of work within the formal sector, which is the casualization, triangulation, etc., of employment. And also importantly, the Decent Work Agenda speaks to the idea of work being decent for all workers. Together with the Declaration of Fundamental Rights and Protections at Work, they both speak to social protection, they speak to rights at work, they speak to inclusion in terms of social dialogue, and the idea there is that a worker should enjoy these protections. And I think what we see is the importance of ensuring that these labor protections are extended in a way that could be meaningful to the workers in that particular sector or occupational group. Here's a market trader in Durban. So very, very quickly in terms of which way, which is a very difficult one. I think if we look at the boundaries of labor law, we've come to a time where we have this legislation which was modeled on a particular system of a particular labor market scenario, which does not necessarily apply, particularly in a developing country context, and which has been overtaken also by events of the digital revolution and so on. We need to think beyond this idea of the employment relationship. So I agree completely with what Darcy was talking about and what CENTROW's mandate is, to think about work and not just to look at employment, because that's quite a restrictive notion. And this idea of addressing inequality is not necessarily about treating workers exactly the same, but it may involve some modifications that will actually ensure that there is substantive equality. So we're not just looking at formal equality to say everyone has the same right, because by extending the same, extending protection in the same way may actually exclude certain workers. So where we're looking at workers that are in an unconventional workplace, domestic workers, for example, need certain additional measures that recognize the fact that they work within intimate spaces, that is an individualized employment relationship within the private home. Non-standard employees require different adaptations that recognize the fact that, for example, if one is working as a fixed-term workers, how these protections are extended to them in a way that is meaningful. Disguised employment relationships, that speaks to this idea of looking at whether we are continuing to be fixated with the notion of employment or whether we're looking more broadly at a worker. And then when we look at own account workers come, the waste pickers, the street vendors, they come with their own needs and their own demands. For example, with social protection, how do we deal with the fact that this is a solitary contributor as opposed to an employer and an employee contributing? Are there ways, for example, for the government to subsidize the contributions, or for corporates that benefit from the work of these own account workers to actually make contributions? It's also important for us to not just look at law on the books or regulation on the books, but look at what is happening on the ground, looking at issues of implementation and enforcement. And it's also important to look at the role of worker organizations in demanding the extension of protection and the realization of equality. And I was glad to hear about other speakers speaking about new and different forms of organization, which are not the conventional, strictly speaking, trade union, the cooperatives, the WhatsApp groups and so on. How can we strengthen these new forms of organizing, and are there ways for collaboration across different sectors or across different occupational groups where that collaborative effort could actually lead to bigger gains for workers? And importantly also, to think about what is the role of employers, how do we bring them in? Is there a role for capital that may not necessarily employ workers directly but benefits from their labor? And when we look at those that are working in public spaces, where do the local authorities come in? So unfortunately, I can't go into some of the details of how we would look at these working conditions, collective bargaining, but maybe we can talk about it in the context of the question and answers. Thank you very much, and sorry for going over.
Thank you very much, Pami. Thank you to all three speakers for not only keeping to the time limits, but also for producing really, I think, innovative and thoughtful contributions to this debate that both allow for us to understand the issue theoretically, as well as to understand the on-ground practice of what's happening in the labor market in South Africa. And I suppose it's one thing that does strike one for a lot of us. One does engage, for instance, with platform work, for instance, when one takes an Uber, when one orders a meal through a courier service, and what the implications are for those providing the services. One of the comments I wanted to pick up on, which underlay a lot of the questions that were posed through the chat room, is really the following. On the one hand, there's a sense of the importance of the issue, almost a frustration that although it's now been an issue that's been on our agenda for many years, it hasn't been dealt with, certainly in central policy debates, and is for instance often the the silence in public documents on the fourth industrial revolution. On the other hand, coming through many of the comments was a concern about the efficacy of labor law per se, and that I suppose that the question really being posed there is, if it's broadly accepted that reform is needed, what are the lessons of the last 30 years in which, you know, a considered set of labour law reforms developed after an intensive process with a level of social partnership perhaps not present any longer, has failed to protect such a large sector of the workforce. So I'd like to just, as we are more due to our technical problems than any of the speakers overrunning their limits, coming to the end of the time, just pose one question to each of the speakers. The first one for Sandra perhaps is within the conventional framework of labour law and the use of test cases, and obviously this has been a significant aspect of the English experience or the British experience. What is her sense of what the role of litigation could be in this arena?
Well, thanks, Paul. So I think litigation plays an important role, and we did have a great victory with Uber and Aslam, as we said, where the UK Supreme Court not only said that Uber drivers were workers, as was mentioned, this hybrid workers, but it also said that the contract as written could be seen as a facade, and the court would look at the real substance of the relationship. So that was a victory, but Uber drivers are already saying that Uber isn't necessarily implementing it yet. It's a good start, but it's clearly not enough, because more needs to be done, as everybody's been saying in the chat, around organising to be sure that there are methods to insist on implementation. But the other side is, of course, you can't always trust the courts. And those of you who might be following UK employment law might have seen the most recent judgment of the UK Supreme Court in what's called the MENCAP case, which is about paying workers for sleep overtime. So this is a central case for care workers who are perhaps the least visible and most exploited, despite all the attention that's been paid during the time of COVID. And the court came out against giving any kind of compensation for the fact that workers are required to be outside of their own homes, are required to be on call, are required to be vigilant, despite, and instead the court simply said, you're asleep, so that's not working time. So I think we need to be very cautious about the kind of litigation strategies we undertake. We can't rely entirely on courts. Courts form a function, but in the end, there needs to be alternative strategies, and litigation strategies need to be very firmly rooted in social movements, in collective organization, and in a way we've always got to think about what do we do with the reversals. How do we turn failures in court into successes on the ground, if at all we can, which isn't impossible. But so I would say we have to use whatever strategies we have available, but litigation is really only one of them, and needs to be very firmly rooted in social movements, collective organization, appeal to popular opinion, and careful thought about what it is we want to achieve and what would happen if we didn't get there.
Thanks very much, Sandra. The question I'd like to pose to Eddie Webster really picks up on the well-known saying that has been present in South Africa for so many years, you know, organize, don't sue, and many people are actually pointing out that does pose a false dichotomy. But I suppose what I'd like to ask Eddie to sort of speculate on at the moment is what role he sees for the established unions in terms of, you know, currently organising workers who might fall outside the scope of the employment relationship, and also what role the union should be playing in trying to shape the work that needs to be done for further labour market reform in this area.
Right. Thanks for the question, Paul. I think that what emerges from our research is that new forms of organization are emerging that are different from traditional unions, in the sense that they are quite hybrid. They could include a cooperative. They could include a kind of Stockfell type relationship where you sharing a rotating credit, maybe money to pay for funerals and so on. And I think it points to the ambiguous nature of the work itself, and the caught between a sense of wanting to be independent and operate independently, but wanting the protection of law. So my general argument would be, I think established unions have responded in the North, in countries like France and the UK and so on, and in fact they formed unions in it. But there's an interesting point that I think that needs further research, and that is that platform work in the South, in Africa or in Johannesburg, may be different from being a Uber driver in Brighton in England. They generally tend to be quite often students, those working part-time, whereas all our drivers that we have in our sample, this is their only job, that they're actually full-time. So there are certain differences about them that may union. But I think that the established unions have a very clear role to play. I think they are fellow workers, and I think they should try and give a voice to these, maybe provide a forum for platform workers to and assist them in their organizing efforts. There may be, in some cases, they may want to recruit them, but I think generally in South Africa, my sense is that the established unions have been quite slow off the mark. And the forms of organization, I mean, we come across we will find, and quite often they're ethnically based, by the way, that say the Ugandan workers will form a WhatsApp group, but it's a kind of quasi-union that they're forming. But it's different from a traditional union, and I think there's a real challenge. And if you look at the history of labour, I mean, that's not surprising, Paul. I mean, if you go back into the history of trade unionism, it starts off as a craft workers, of skilled workers. Those skilled workers lose their skill through mechanization. You get the introduction of Fordism, you get industrial unions. So if you look at the history of labour, they've always constantly changed the forms of organisation. So the question, for me, the interesting puzzle for researchers, and I think that, I think this CENTROW is looking for research questions and research agenda, I think would be to understand the exact form of organisation that's merging, rather than impose an organisation on that, to actually try and build a new form of organisation that meets the needs, aspirations, and what the job means for those men and women. I mean, one problem, one fundamental problem, is that a lot of them, from our research, are cross-border migrants. So it opens up a whole lot of areas of vulnerability. So new worker, new form of organisation. That's my response, Paul.
All right, thanks very much, Eddie. And you've raised the cross-border issue, and that's the one I wanted to pose to Pami, and I apologize if it's perhaps the most difficult, and certainly in our current context, the most controversial. Some of the questions posed have raised the issue of whether we now should be looking at a Southern African labour market. Eddie's research indicated what I think is widely perceived, and that is that large platforms in many instances employ non-South Africans, sometimes as a sort of a strategy for lowering rates and that. So perhaps if you could comment on that, Pami.
Well, that's a difficult one, but I think looking at the realities, I guess, particularly in South Africa, where the majority of workers are, where the majority of migrant workers are situated currently, there certainly has been some recognition within the SADC, for the need to recognize the rights of migrant workers, to recognize the realities of migration, and ensure that there are systems in place to ensure that these workers are protected. The challenge will always be, I guess, where the migrant sending countries would be in favor of these types of regimes, but South Africa hasn't particularly been so thrilled about this kind of movement because of the implications. I guess it would be South Africa, Botswana, and maybe Namibia, which are the more prosperous and migrant receiving countries. So the challenge then becomes whether consensus could actually, well, even though there's consensus, there's been adoption of these, the labor migration framework, whether the implementation thereof actually takes place in light of the reservations of the receiving countries.
Thanks very much, Pami, and thanks for those questions and those answers. We're close to 1 o'clock, so I'm not going to put any further questions to the panelists, but thank you very much for your participation. I think this has been an excellent choice of speakers, and it's certainly highlighted for us the challenges that we face. And perhaps I'll just return to some of the projects that we are running with, because they do, I think, illustrate how we would like to engage with others, working on an ongoing, on a future basis in this area. The DPCP, which is a platform around cooperative platforms, and it's really perhaps best understood as an attempt at looking at what are the alternatives to the current rather harsh commercial platforms that have operated. It's working particularly in the areas of domestic work and care work, two areas where employees have obviously both through lack of organization and lack of rights traditionally been exploited. But it's certainly, I think, a very important starting point for an important debate that needs to be had as to if platforms are the current reality and what we need to engage with, and though they only may affect a small percentage in current terms of the labour market, they certainly have a very significant effect on the character of work, and one of the points Eddie made. So that's certainly one area where I think we, as CENTROW, would like to continue to engage. One of the other issues, just that I'm interested in from a regulatory perspective, is, and I see it's been raised in some of the questions, is the particular difficulties of the regulation of transport. And if we look at, it's an area obviously where platforms play a particular role, and where the many of the legal issues are particularly complex. when a motorbike driver working for a courier company crashes, is that an occupational accident? Is it a road accident? Who is responsible? The issue of regulating platform-based driving has been the subject of an attempt to alter the Land Transport Act that has been ongoing for 5 or 6 years. And while in many areas the issues of regulation are complex, I think in an area like transport they're particularly complex and require addressing a range of issues that haven't been dealt with adequately in the past. The third issue, and that this is raised obviously by the role of unions and the issues of registration, is what is the correct entry point into the regulatory debate. And it's a debate that has to some extent begun to occur in NEDLAC, and that is that one could envisage a major legislative reform in which new legislation is developed in trying to incorporate the different forms of work. The other is to accept that it's perhaps to immediate an issue for that, and that in fact administrative mechanisms do exist already for allowing the extension of labour law to these areas through the minister's powers to deem. And one of the areas that needs to be debated is how perhaps to raise that issue from a public debate more centrally, so that in fact discretions could be exercised in favour of workers whose status is in many cases, I think it's clear they're employees. There's no doubt that a domestic worker employed by a platform is in fact is an employee. The question of Uber drivers is somewhat more complex, but undoubtedly many of them, and particularly people like courier drivers, are in all probability employees. But it does seem to me that there's been a failure to raise the administrative possibilities of these issues, and that's a further area. The other area that I'd like to raise is the question of information. And I want to really highlight one of the other programs that CENTROW is running, that is the Labour Law Online project. And this is really a project which seeks to make information about labour law available to employees, particularly employees outside unions, and it's envisaged, and I'm glad to see that there are many community law centres participating, that hubs could be established where employees with difficulties in terms of access to the law could access information, and that's certainly one of our key projects, and one which we do want to work further on with the grouping of community centre clinics and others. And it does seem to me that also incorporates an aspect of digital work. It seems to me that the need for information about rights, even though they may not fully be extended yet to that sector, applies equally to the to digital work. And that really, I suppose, is one of the issues that ultimately our project needs to engage, and that is, labour law deals with inequality, it deals with exclusion. The forms of inequality and exclusion may extend over time. And though there's almost a perpetual process of catch-up where law and where organisation seeks to address exclusion and inequality, there's no reason why the fact that certain people may have been inadequately dealt with in the past doesn't, prevents endeavors to open up those areas to greater protection and regulation. And so certainly our project in that regard is because in many ways it's a project that builds on past inequalities, is to make a contribution to the debate, both through research and through organization, and all of our projects, I think, try and span those two areas. So those really, I want to thank everyone for being with us. It's been a very useful debate. I think because of the large numbers, not everyone has had a chance to raise questions or to indicate areas in which they would like to see an organization like CENTROW working. So I would encourage people to communicate with us as to the type of projects, the type of future engagements you would view as valuable, and hopefully from that we can build a really worthwhile project. So with that, I thank all our presenters, those from the university, those from outside, who've allowed us really to have what I think has been a very, very significant and successful occasion. And thanks to everybody, and we hope to work with you in the future.
Thank you. Thank you to everybody, and bye-bye.